I want you to imagine a scenario for a second. You wake up, you have your morning coffee, you commute to work.
Right. Just a totally normal Tuesday.
Exactly. And maybe you are, I don't know, a furniture removalist. You're just driving a truck, doing the heavy lifting you're literally paid to do. Or maybe you're a local council worker checking building permits.
You're just following the municipal checklist. You're just doing your job.
Right. You're simply doing your job. And then, completely out of the blue, a formal legal letter arrives at your home. You are being sued in the Supreme Court.
Oh, man. Immediate panic.
Utter panic. So you scrape together your savings, right? You hire a lawyer to navigate this whole labyrinth of legal filings. You endure all this immense, sleepless stress of a pending trial.
Because the Supreme Court trial is no joke.
It's terrifying. And finally, after months of this anxiety, the judge dismisses the claim as completely baseless.
You breathe a massive sigh of relief.
You do. It is finally over. But then a few weeks later, another letter arrives. You are being sued again.
By the exact same person.
By the exact same person. Over the exact same baseless claim. And this doesn't just happen twice. It happens dozens of times, stretching over years.
Just systematically bleeding you dry.
Financially and emotionally, yeah. You have suddenly become the victim of what the legal system calls a vexatious litigant.
It sounds like an obscure, rare nightmare, right? But by the mid-2000s, this phenomenon was quietly tearing the justice system apart from the inside.
Which is wild to think about.
It really is. It was creating an administrative and, honestly, a financial crisis. And that crisis forced the Victorian Parliament to realize they were dealing with this deeply complex behavioral issue.
One that traditional law was utterly unequipped to handle.
Exactly. So they launched a massive inquiry, which resulted in a really comprehensive 2008 final report by the Law Reform Committee.
And the goal was to figure out who these serial suers actually are, right? Like why they cannot stop.
Yeah, and more importantly, how a democratic society can protect innocent citizens without accidentally destroying fundamental civil rights in the process.
Okay, let's unpack this. Because right out of the gate, we hit a massive democratic tension.
We really do.
If we look at the foundation of a free society, access to the courts is, well, it's an absolute tiller. The courts are supposed to be the great equalizer.
They have to be open to everyone.
Right. But on the other side of that coin, there is a desperate need to stop individuals who essentially weaponize that open-door policy.
People turning the machinery of justice into an instrument of personal harassment.
Exactly. So to understand how a legal system tries to navigate that tension, we first have to look at the strict boundaries of what constitutes this behavior, right?
Yeah, because the law cannot operate on vibes or, general annoyance.
Can't just be like, oh, this guy's super annoying, ban him.
Right, exactly. In Victoria, the boundary was drawn by Section 21 of the Supreme Court Act, 1986.
Okay, Section 21.
Under this legal mechanism, a person can only be declared a vexatious litigant if they and I quote, habitually, persistently, and without any reasonable ground, instituted vexatious legal proceedings.
Yeah. Okay, those three words. Habitually, persistently, and without reasonable ground. They do a lot of heavy lifting here.
They absolutely do.
Because when you dig into the legal precedents interpreting that phrase, it becomes clear the threshold isn't just high, it's practically stratospheric.
It has to be.
Like, habitually doesn't mean filing 2 or 3 annoying lawsuits over a decade.
No, not at all. The courts interpret it to mean that initiating litigation has basically become a matter of course for the individual.
It's their default reflex.
Exactly.
Yeah.
Any friction in the world, they sue. And then persistently implies this stubborn, just immovable determination.
They just do not accept a loss.
Never. And without any reasonable ground means the actions are hopelessly baseless. We're looking at a mountain of court files, relentless appeals, and a total detachment from legal reality.
Which makes sense, but, well, the courts have to set that threshold at the absolute extreme, don't they? Because the right they are threatening to take away is so fundamental.
Yeah, it's massive. During the early attempts to introduce these laws in Victoria, back in 1927, there was a parliamentarian named Maurice Blackburn.
Okay.
And he passionately argued against them. His stance was that public policy dictates every single person who believes they have a grievance must have the opportunity to seek redress.
Right. You don't sacrifice that universal right just because, what does he say?
He called them 1 or 2 cranks.
Yeah.
You don't sacrifice the system for 1 or 2 cranks abusing it.
And the UN backs that up today, right?
We do. The United Nations Human Rights Committee classifies access to the administration of justice as a guaranteed human right under international covenants.
But at a certain point, the theoretical right to access the court clashes with the practical reality of a functioning society.
It really does.
I always think about it like a restaurant.
Okay, lay it on me.
So you have a diner patron who orders a steak. The steak arrives perfectly cooked, but the patron claims it's raw and sends it back.
Happens all the time.
Sure, the kitchen, operating in good faith, cooks a new one and sends it out. The patron sends it back again.
Right.
Now imagine the patron does this 50 times in a single evening.
Oh my God.
Just screaming at the waitstaff, demanding to see the chef, refusing to leave the table.
Okay, yeah, that's a problem.
Exactly. The restaurant fundamentally exists to serve food to the public. But if the manager doesn't eventually ban that specific patron, the kitchen shuts down, the staff quits, and literally none of the other customers can eat.
That is a great analogy. And the problem with that restaurant scenario when applied to the law is that the patron doesn't just yell at the waiter.
What do they do?
Eventually, they sue the chef, they sue the supplier of the beef, and they sue the person who manufactured the dining room chairs.
Oh, wow. Right. It just spreads.
It does. But to use your analogy, the manager has to be incredibly careful not to accidentally ban someone who legitimately received a cold meal.
Or someone who is just, struggling to read the menu.
Exactly. This is why the Law Reform Committee report meticulously maps out what they call a spectrum of litigation behavior.
Because difficult does not equal vexatious.
Precisely. The justice system encounters difficult, frustrating people every single day.
So if we visualize the spectrum, on the far left, you have individuals bringing perfectly meritorious claims.
Right, totally standard lawsuits.
Moving slightly to the right, you find people who have entirely valid grievances but fail in court because they just lack communication skills.
Yeah, maybe they don't speak English as a first language.
Or they simply cannot decode the complex, archaic formatting required for a legal affidavit. I couldn't do it without a lawyer.
It's incredibly difficult. And further down the line, you encounter passionate activists pursuing deeply unpopular but legally permissible causes.
Right.
You also find individuals who are under immense stress, acting out with a challenging or abrasive courtroom demeanor, just because their entire livelihood is on the line.
And crucially, that spectrum also includes people with disabilities or mental illnesses, right?
Yes. People who might repeatedly interact with the legal system to address genuine systemic discrimination they face in their daily lives.
So the danger here, which the report really highlights, is the sheer administrative ease of mislabeling someone as a pest.
Exactly. Just because they don't conform to the polite, polished norms of a traditional courtroom.
Right. Because when an overwhelmed court clerk or a really frustrated judge interacts with a self-represented litigant who is highly emotional and disorganized,
The temptation to categorize them as vexatious is so strong.
it's just the easiest way to clear the docket. And this is exactly why you, the listener, should care about the rigidity of these definitions.
It affects everyone's access to justice.
It does. If the system starts loosely applying the vexatious label to anyone who is difficult or unrepresented, it creates this massive chilling effect.
The Mental Health Legal Center provided really stark testimony to the committee about this.
What did they say?
They emphasized that marginalized people, particularly those with mental health challenges, already face profound barriers to being heard.
Right.
If their legitimate complaints are casually dismissed or pathologized as mere harassment, the legal system inadvertently becomes an instrument of oppression.
The threat of being labeled a serial suer can literally silence actual victims.
Exactly. That underlying risk of oppression is why Section 21 of the Supreme Court Act was designed as an absolute last resort.
Wielded only at the extreme right edge of that behavioral spectrum.
Yes. To cross that line in Victoria, you have to demonstrate a pattern of behavior so egregious and unyielding that only the Supreme Court, the highest court in the state, is authorized to make the declaration.
And only the state's chief law officer, the attorney general, can even initiate the application, right?
Right. It's a massive hurdle by design.
So we have this incredibly strict legal definition acting as a barrier to protect the public. We are not talking about the passionate activist or the confused citizen.
No, we are talking about the absolute extreme end of human stubbornness.
Which naturally brings up the question of identity. Who actually are these people?
This is where it gets really surprising.
Because if you look at the demographic data in the report, it completely shatters your intuitive assumptions.
Yeah, you might picture like a young, rebellious, anti-establishment type.
Or perhaps some slick corporate operator trying to game the system.
But the reality is vastly different. The declared vexatious litigants are overwhelmingly older men.
Older men, okay.
Yeah, in Victoria, 12 of the 15 declared litigants were male, and they almost universally began their relentless litigation campaigns in their 30s, 40s, or even much later in life.
That is so specific. When researchers and legal scholars analyze that specific demographic men entering middle age, what do they point to?
They often point to a period in life where individuals are highly sensitive to a loss of status, control, or identity.
So a midlife grievance, whether it's a divorce or a business failure, it isn't just experienced as a legal problem.
Exactly. It is internalized as a profound existential threat.
And that aligns perfectly with the origin points of these legal sagas. They do not begin with grand constitutional battles, do they?
No, they begin with the most agonizingly mundane, everyday frictions.
Like what?
A property line dispute over a fence, a denied permit for a shed, a defaulted mortgage.
Right. I was reading through the actual case studies in the report, and this mundane reality scaling into absolute madness is perfectly captured by case study 1, Mr. A.
Oh, Mr. A. He holds a very dubious honor.
He does. He is Victoria's very first declared vexatious litigant, officially banned in December 1930.
Over 90 years ago.
Yeah. And when you look at his background, he was an incredibly driven, dynamic guy, an inventor, an entrepreneur, a builder.
By the mid-1920s, he was importing gasoline, lodging patents for internal combustion engines.
Drafting ambitious plans for a new shipyard. I mean, he was relentlessly petitioning the premier to invest in petrol-powered railroad cars.
He was a man accustomed to pushing big ideas into the world.
Totally. But his collision with the justice system didn't happen over some massive industrial patent.
No, it started with friction over local bureaucracy.
As always.
Right. He became entangled in a dispute over new municipal bus licensing laws. This resulted in him issuing summonses against city inspectors, claiming they were operating outside their jurisdiction.
And then there was the house. This is where the obsession truly crystallized for him.
The famous kerosene house.
Yes. So Mr. A built a prototype for what he called a fireproof house, and it was constructed entirely out of empty kerosene tins and reinforced concrete.
Just a bizarre structure to begin with.
Completely. So he built this structure, and the local Shire of Heidelberg stepped in and demolished it for violating building codes.
Which, I mean, you can kind of see why they would.
Yeah, empty kerosene tins don't exactly scream structural integrity, but that demolition didn't just anger him, it triggered an absolute avalanche of retaliatory legal filings.
He was subsequently bankrupted for failing to pay the legal costs of his initial challenges.
And instead of stopping, he accelerated.
He really did. According to the historical court records, between 1926 and 1929, Mr. A personally filed 120 separate legal proceedings.
Okay, we have to pause here. We have to contextualize what 120 proceedings actually meant in the 1920s.
It is mind-boggling.
This was not clicking a mouse to generate an email. This required drafting documents by hand.
Or on a heavy manual typewriter.
Exactly. It required purchasing physical stamps, binding paper, navigating the postal service, and physically traveling to different courthouses to file motions and attend hearings.
Just the sheer caloric and financial energy required to sustain 120 lawsuits in 3 years is staggering.
It's exhausting just thinking about it. Who was he even suing?
Everyone. He initiated private criminal prosecutions against the Shire of Heidelberg, individual local councillors, city staff, the broader city of Melbourne, the Commissioner of Public Works, the Melbourne Tramway Board.
Just widening the net every time.
And eventually, he sued the proprietors of the daily newspapers who reported on his antics.
Wow, it just became his full-time occupation.
It completely consumed him.
And despite all of that effort, none of his actions were successful. The Supreme Court finally intervened and utilized the newly minted laws to ban him from commencing legal proceedings without a judge's prior leave.
And how did he react?
Well, he immediately appealed that ban to the High Court and lost again. But the most chilling part of Mr. A's story is that the ban didn't actually cure the obsession.
It never really does. The report explicitly notes that his litigation was slowed but not stopped.
Right. He spent the next several decades finding creative loopholes. Sometimes he would file proceedings under his brother's name just to keep the fight alive.
By the 1960s, this once prolific inventor was entirely consumed by his grievance.
It's actually really sad. He was living in absolute poverty, drifting between stables, warehouses, and garages.
Constantly carrying a weathered suitcase crammed with legal papers.
He spent his entire life, up until his death at age 82, litigating the ghost of a kerosene tin house.
It is a devastating trajectory. It really illustrates how the litigation consumes the litigant just as much as it consumes the court's resources.
It's like an addiction.
It is. And we see a similar, highly intense pattern in case study 2 from the report,
What?
Mrs. B.
Right, Mrs. B. She was declared vexatious in 1941.
And her background was remarkably different from Mr. A's. She was a composer and a classically trained musician who had performed across Paris and London in her 20s.
So highly educated, worldly.
Very much so. However, in 1938, she married the brother of a former high court judge, and the marriage dissolved a mere year later.
Okay, but most marital breakdowns, even the highly contentious ones, eventually settle through standard divorce proceedings.
Usually, yes. But Mrs. B's case rapidly mutated into something else entirely. Over the next 18 months, she unleashed 9 separate, sprawling legal actions.
What was her core claim?
Her main argument was that her ex-brother-in-law had utilized undue influence to strip her of her share in the marital home. And she claimed he had effectively forced her to vacate the property by maliciously turning off the utilities.
Okay, so a very messy family dispute. But her vengeance wasn't confined to her ex-husband's family, was it?
Not at all. She widened the net, filing lawsuits against the pawnbrokers she claimed she was forced to sell her jewelry to in order to survive.
Which makes no sense. The pawnbrokers didn't do anything wrong.
Right. And most bizarrely, she sued the furniture removalists.
Wait, really? The movers?
Yes, the hired laborers who arrived with a truck to physically move the furniture out of the house.
That detail perfectly underscores the collateral damage of this behavior. The furniture removalists had absolutely no stake in the marital dispute.
They were just doing their job. They were simply executing a contract.
Yet they found themselves defending a Supreme Court action.
Which is incredibly stressful and expensive.
And when we look closely at these case studies, a really clear operational pattern emerges regarding how these individuals actually enter the legal arena.
Because the prevailing assumption is that vexatious litigants are inherently litigious people who wake up looking for someone to sue.
Like they're just aggressive by nature.
Exactly. But the data reveals a fascinating inversion.
Right, they rarely start out as the plaintiff on the offensive. They almost always begin the journey as the defendant.
This is such a key point. Professor Steve Headley conducted a comprehensive study of 105 vexatious litigants in England and Wales, and his findings firmly established this.
The vast majority were dragged in.
Yes, the vast majority of these individuals were initially dragged into the court system against their will.
You see this mirrored perfectly in the Victorian report's other case studies, too. Take Mr. C, for example.
Remind me about Mr. C.
So he decided to build a fence on his property without bothering to secure a local municipal permit. The council noticed, issued a fine, and prosecuted him for the unpermitted structure.
So he was the defendant.
He was the defendant and he lost. Or consider Mr. Pay, who unfortunately defaulted on his mortgage payments. The bank, acting on the contract, initiated legal action to repossess the land.
Again, he was the defendant and he lost.
The initial interaction with the justice system is purely defensive.
But the experience of losing, of having the state or an institution force a negative outcome upon them, somehow acts as a radicalizing event.
It's like a psychological shock. The loss causes them to completely flip the script.
They transition from defensive subjects to permanent aggressive plaintiffs. They utilize the very legal system that punished them as a weapon of retaliation.
Which is such a dark irony. And once that radicalization occurs, the progression of their lawsuits is not random, is it?
No, it's actually highly structured. Researchers, including Chris Wheeler, the former deputy ombudsman in New South Wales, alongside Professor Headley, have analyzed thousands of these cases.
And what do they find?
They identified 3 highly distinct, predictable strategies that these litigants employ to sustain their campaigns.
Let's break down the mechanics of these strategies, because this is where the sheer persistence becomes terrifying. Based on the research, the first evolutionary stage is known as the rubber ball strategy.
Or the obsessional approach. This is the most straightforward mechanism.
So the litigant loses their initial case, say the dispute over the unpermitted fence. The judge issues a final ruling, but the litigant simply refuses to acknowledge the reality of the loss.
They literally bounce back.
Right. They file a new complaint regarding the exact same fence against the exact same local council.
And when that gets thrown out, which it will, they might tweak a single paragraph, change the title of the legal motion, or invent a new minor technicality and throw it at the court again.
They are obsessively hammering away at the same brick wall utterly convinced that if they just file the paperwork one more time, the wall will shatter.
It is a cycle of perpetual replication, just endless.
But the true systemic crisis occurs when the litigant graduates to the second strategy, right?
Yes. This is what researchers categorize as rolling thunder, or the conspiracy strategy.
Rolling thunder. That sounds ominous.
It is. This is where the scope of the litigation aggressively and malignantly expands.
I always think about it like a virus. If the rubber ball strategy is a battering ram against one door, rolling thunder is a virus that actively mutates to infect the court's own immune system.
That's a really good way to put it.
Because in a normal dispute, the court acts as the white blood cells, resolving the conflict. But when a rolling thunder litigant loses, they don't just sue their neighbor again.
They rationalize the loss by deciding the system itself must be inherently corrupt. Because in their mind, why else would they lose?
Exactly. So they sue the judge who handed down the ruling. They sue the lawyers who represented the opposing side. They turn around and sue their own lawyers for alleged malpractice.
They issue subpoenas against the witnesses who testified against them.
Every single rejection, every dismissed motion becomes undeniable proof of a massive systemic conspiracy orchestrated specifically against them.
Exposing that conspiracy becomes their consuming life mission.
Which is terrifying for anyone caught in their path.
And the virus analogy is highly accurate because it describes a mechanism of systemic failure.
How so?
The very rules designed to ensure a fair trial. The right to appeal, the right to file motions for discovery, the right to cross-examine are hijacked to paralyze the institution.
The litigation just spreads outward.
It absorbs clerks, bailiffs, and registry staff into this paranoid narrative.
Wow. And then you have the third most chaotic strategy, the scattergun.
The scattergun is just total chaos. They abandon any central unifying grievance.
So it's not even about the fence anymore.
Not at all. These individuals operate multiple, totally disparate legal battles simultaneously across various jurisdictions.
So they might be suing their local council in one court over a drainage issue, while concurrently suing a national bank in federal court over a complex financial instrument.
All while aggressively appealing a minor municipal traffic ticket to the highest appellate court in the state.
It's everywhere all at once.
Exactly. And what's fascinating here is that this highlights one of the most perplexing paradoxes documented in the report.
Oh, about where they choose to fight these battles.
Yeah. If you are a self-represented individual looking to dispute a minor municipal fine or a neighborhood property line, the logical, accessible route is to utilize a local magistrate's court or a specialized civil tribunal.
Right, because these venues are specifically designed to be cheaper. The procedural forms are simplified, the environment is way less formal.
Exactly. Yet vexatious litigants are almost magnetically repelled by these accessible options.
They are drawn obsessively to the superior courts, the Supreme Court and the Court of Appeal, which makes absolutely no strategic sense, right? I mean, the Supreme Court involves massive filing fees, highly complex rules of evidence, and a huge risk of having costs awarded against you. Why bypass the easy route?
The answer lies in the grandiosity of their perception. The report quotes a highly revealing interaction from a frustrated magistrate.
What?
When this magistrate attempted to explain to a litigant that their particular claim for damages far exceeded the jurisdictional financial limits of the lower court and therefore couldn't be heard there.
So the litigant was probably crushed, right?
No. The litigant didn't react with disappointment. Instead, they excitedly exclaimed, "Oh no, my case is worth millions."
Ah, so it's a feature, not a bug for them.
Precisely. To the vexatious litigant, their mundane dispute over a fence or a parking ticket is not minor. It is a matter of historic, constitutional importance.
They believe they are fighting the ultimate fight.
Therefore, they believe that only the highest court in the land, presided over by the most senior judges adorned in traditional robes and wigs, possesses the gravitas required to hear their grievances.
You routinely see them bypassing local ordinances and immediately citing foundational historical texts, don't you?
Oh, constantly. Arguing that a local council parking fine violates the Magna Carta or contravenes the foundational principles of the national constitution.
Here's where it gets really interesting. When you look at the mechanics of this behavior, the absolute inability to accept a loss, the paranoid mutation of rolling thunder where everyone is conspiring against them, the profound grandiosity of citing the Magna Carta to fight a $20 ticket.
The system is eventually forced to ask a very uncomfortable question.
Exactly. When a court clerk is watching someone handwrite their 120th lawsuit, is the system dealing with a calculated legal strategy or a medical crisis?
Are these people just Incredibly stubborn, entitled individuals abusing a public service, or is this an actual psychiatric condition playing out in a courtroom?
This specific question generated the most intense, multidisciplinary debate within the entire law reform committee inquiry, didn't it?
It did. Because for centuries, the justice system treated this purely as an administrative and legal problem.
Right, just file the paperwork, reject the paperwork.
But dating back to the 19th century, European psychiatrists began observing and documenting a specific behavioral disorder characterized by the obsessive pursuit of complaints and litigation.
What did they call it?
Historically, the medical literature has labeled this querulous paranoia, litigious paranoia, or sometimes categorized it within de Clerambault syndrome.
Yeah.
During the inquiry, prominent forensic psychiatrists, such as Professor Paul Mullen, strongly advocated for recognizing the mental health dimension of this behavior.
What was his argument?
His testimony highlighted that these individuals are often deeply damaged people, driven by a profound pathological sense of injustice, and that simply throwing rigid legal sanctions at them without understanding the psychology only exacerbates their damage.
Okay, I have to push back here. Because this is where the philosophy gets incredibly thorny for me.
It is a minefield.
If the state begins adopting a framework where anyone who relentlessly sues the government or challenges institutions is categorized as mentally ill, aren't we walking into incredibly dangerous territory?
You're touching on the exact fear many advocates had.
It echoes a dystopian authoritarian tactic, Oh, you are persistently criticizing the state apparatus. You must be suffering from querulous paranoia. Let's legally silence you under the guise of medical treatment. I mean, if a citizen actually uncovers genuine, deep-seated corruption in their local council, and they absolutely refuse to let it go despite facing massive systemic resistance, the last thing we want is a judge dismissing them as psychiatrically unstable just to clear the court docket.
That exact concern was fiercely articulated during the committee hearings. The Mental Health Legal Center provided a stark warning against the medicalization of legal grievances.
What did they argue?
They argue that taking a citizen's legal complaint and forcibly applying a psychiatric model to it is fundamentally dismissive and paves the way for severe human rights abuses.
Because the line is so blurry.
Extremely blurry. As noted in the psychiatric literature reviewed by the committee, the dividing line between a citizen exhibiting paranoid ideation and a citizen exhibiting a normal, objective, and deeply held desire to utilize the legal process to obtain justice is incredibly hard to define.
And judges aren't doctors.
Exactly. Judges are experts in jurisprudence, not psychiatry. The legal system is not architecturally designed, nor are its officers trained to make clinical diagnoses.
If court clerks and judges start casually assigning psychological labels to litigants, the genuine victims of institutional discrimination, who may present as highly distressed or obsessive because they are actually being victimized, will be denied their fundamental rights.
Which is a catastrophic outcome for justice.
So the committee is trapped between two immovable forces. The psychiatrists are warning, these individuals require behavioral management, not just punitive court orders, because your legal orders are fueling their paranoia.
And meanwhile, the human rights advocates are warning, keep medical diagnoses entirely out of the courtroom or you will destroy the foundation of civil liberties.
How on earth did the 2008 report attempt to reconcile that massive ideological clash?
They found a pathway forward through a framework known as therapeutic jurisprudence.
Therapeutic jurisprudence, what does that actually mean?
It isn't about turning the courtroom into a clinic. It is a legal philosophy that recognizes the law itself as a social force that inevitably produces either therapeutic or anti-therapeutic consequences for the people involved.
Okay, so the process itself has a psychological impact.
Yes, it requires the legal system to acknowledge the deeply human behavioral realities at play and fundamentally redesign its structural procedures so that the machinery of the court doesn't actively pour gasoline on a litigant's mental state.
Explain the mechanics of that. How does a court structurally change to practice therapeutic jurisprudence without becoming a therapist?
It starts by examining the mundane administrative processes that trigger the behavior. Imagine an individual who is already highly suspicious of authority.
Okay.
They spend weeks drafting a sprawling, emotionally charged 50-page affidavit detailing a perceived injustice regarding a property line. They submit it to the court.
And historically, what does the court do?
The court's automated response is to mail back a cold, highly technical legal document stating that the pleading has been struck out for failing to disclose a reasonable cause of action, citing obscure procedural rules.
Just totally cold and bureaucratic.
Right. To an individual suffering from querulous paranoia, that impenetrable, jargon-filled rejection is not seen as a procedural correction. It is interpreted as concrete evidence of the conspiracy.
Wow. It proves the court is colluding with their enemies to silence them.
Exactly. The legal jargon itself acts as an anti-therapeutic trigger, escalating their anger and launching them into the rolling thunder phase.
So the court's own communication style is unwittingly radicalizing them further.
Exactly.
Yeah.
Dr. Grant Lester and researchers involved in the Australian Parliamentary Ombudsman's Project argue that under therapeutic jurisprudence, the court must change its architecture of communication.
How so?
This involves training registry clerks and administrative staff in human de-escalation tactics. Instead of hiding behind archaic legal phrasing, court communications can be redesigned to acknowledge the individual's frustration while setting incredibly clear, calm, and firm limits on what the court can and cannot do.
That makes a lot of sense, just treating them like a human being first.
Justice Kevin Bell, the president of the Victorian Civil and Administrative Tribunal at the time, testified about the enormous psychological stress placed on frontline court staff dealing with abusive, persistent litigants.
It must be an awful job sometimes.
By training the staff to recognize the behavioral patterns, to see the screaming litigant not just as a legal nuisance, but as a human being locked in a predictable psychological spiral, the court can manage the interaction more safely.
Protect its staff and potentially prevent the litigant's paranoia from mutating into a lifelong crusade.
Exactly. It fundamentally shifts the court's role from just mechanically stamping and rejecting paperwork to actively managing the human friction.
And that management is vital because if left unchecked, the blast radius of this behavior is catastrophic.
The ripple effect is huge.
We've spent a lot of time analyzing the psychology of the litigants themselves, but we really need to look at the people caught in the crossfire.
The victims.
Yeah, the toll of vexatious litigation is staggering.
The mathematical asymmetry of the damage is profound. As we noted, there had only been 15 successfully declared vexatious litigants in Victoria between 1928 and the publication of the 2008 report.
Just 15 people over 80 years?
Yet those 15 individuals were responsible for generating hundreds and likely thousands of baseless, complex lawsuits.
The financial drain on the publicly funded justice system must be immense.
Oh, it is. When a Supreme Court judge is forced to spend days untangling a scattergun litigant's 80th incoherent appeal, they are fundamentally unavailable to hear the case of a genuine victim.
Perhaps someone injured in a workplace accident who's been waiting 2 years for a trial date.
Right. It constitutes a massive misappropriation of taxpayer money and finite judicial resources.
And I want to emphasize why this matters directly to you, the listener. It is incredibly easy to brush this off and think, while the government has entire departments of lawyers on salary and massive corporations have infinitely deep pockets, who really cares if a bank or a municipal council gets sued a few extra times?
But that's not who bears the brunt of this.
No. As we saw with Mrs. B suing the laborers who moved her furniture, or another case in the report where a litigant sued the local real estate agent who simply facilitated the sale of a farm, the collateral damage almost always sweeps up everyday working-class people.
Small business suppliers, innocent bystanders called as witnesses, low-level administrative clerks.
Because if you, as a private citizen, receive a summons to the Supreme Court, you cannot just ignore it.
If you ignore it, you risk a default judgment being entered against you.
Which could ruin your life.
Huh.
You are essentially forced to hire legal representation just to draft a formal defense proving you have nothing to do with the madness.
And that process easily costs thousands, if not tens of thousands of dollars.
Meanwhile, the vexatious litigant who is representing themselves isn't paying hourly legal fees.
They have the infinite time and energy of their obsession.
They can simply continue to generate and file paperwork day after day while the everyday citizen is literally pushed toward financial ruin and bankruptcy trying to defend themselves against a ghost.
The financial devastation is inextricably linked to severe emotional trauma, too.
I can't even imagine the stress.
Having your professional reputation publicly attacked in court filings, having your personal privacy invaded through endless aggressive subpoenas, and living under the constant looming anxiety of when the next legal threat will arrive in the mail.
It must exact a massive toll on a person's mental stability and their family life.
During the inquiry, Mr. Matthew Carroll, representing the Victorian Equal Opportunity and Human Rights Commission, made a critical intervention regarding this balance.
What did he say?
He argued that the debate over human rights had become too skewed toward the litigant. He pointed out that while access to the court is a right, Everyday citizens also possess a fundamental human right not to have their privacy, family life, and reputation unlawfully and repeatedly interfered with by a weaponized legal process.
So what does this all mean for the philosophical concept of justice itself? If the system allows this to continue, does it break the core promise of the courts?
If we connect this to the bigger picture, this systemic failure absolutely fractures the rule of law.
How so?
A foundational cornerstone of any functioning justice system is the concept of finality. When two parties enter a dispute, the court hears the evidence, perhaps an appeal occurs, and eventually a final binding decision is rendered.
Right. And then it's over.
Once that decision is made, the state guarantees that the parties can walk away and resume their lives. The conflict is over.
But the vexatious litigant never lets it be over.
Exactly. The master of the rolls in the United Kingdom summarized this brilliantly. He argued that if a legal system permits litigation that serves no purpose other than to endlessly reopen and relitigate the exact same resolved dispute time and time again, the courts are actively denying defendants their fundamental right to finality.
A justice system that is structurally incapable of finalizing a decision ceases to be a justice system.
It becomes a state-sponsored venue for perpetual harassment.
Which brings us to the critical breaking point of the 2008 report. If the philosophical damage is this profound, and if the practical reality is that everyday citizens are being financially ruined by these lawsuits, why on earth had Victoria only successfully banned 15 people in 80 years?
It's an absurdly low number compared to the devastation being caused.
Why wasn't the system stopping them?
The failure was entirely mechanical. The legal tool designed to stop them. Section 21 of the Supreme Court Act was deeply flawed. It acted as a massive restrictive bottleneck.
Okay, walk us through the bottlenecks.
The first major structural flaw was that Section 21 was an all-or-nothing nuclear option.
Meaning?
If the court declared you a vexatious litigant, you were effectively banned from instituting any legal proceedings in any court or tribunal in the state regarding any subject matter without prior judicial permission.
Wow, just a total blackout.
Yes. And because it was such an absolute draconian restriction on a fundamental human right, judges were incredibly and rightly hesitant to deploy it unless the litigant's historical behavior was astronomically egregious.
Right, it's the equivalent of a doctor amputating an arm to cure a broken finger. The cure is so extreme that they simply refuse to do it until the patient is practically dead.
Precisely. And the second, even more restrictive bottleneck was the question of who was actually allowed to wield that nuclear option.
Who could ask for it?
Under the old law, the only entity permitted to apply for a vexatious litigant order was the Attorney General, and the only venue that could hear the application was the Supreme Court.
Let's play that out practically. If I am the furniture removalist and I have been dragged into court 20 times by the same obsessively litigious individual, I cannot simply walk up to the judge overseeing the case and say, "Your Honor, look at this file. Please issue an order to make this person stop."
Nope. You were legally barred from asking for your own protection.
I have to somehow navigate the political bureaucracy, get the attention of the state's highest law officer, the Attorney General, and convince their massive, slow-moving department to take up my cause and prosecute an application in the Supreme Court on my behalf.
Yes. The average victim of vexatious litigation was entirely disenfranchised from seeking their own protection.
That is maddening.
It created an insurmountable administrative hurdle. The Attorney General's office, which is dealing with statewide legislative issues and major criminal prosecutions, had to divert resources to investigate the litigant's entire history.
Compile massive evidentiary briefs of their previous lawsuits, dedicate senior counsel to argue the application.
Because it was so resource-intensive, the Attorney General rarely pursued it.
Consequently, the law just sat unused on the books.
And everyday victims were left completely defenseless for years while the litigant's behavior escalated unabated.
So the nuclear option was a total failure. How did the Victorian Law Reform Committee propose fixing the architecture of the law?
The committee recommended a complete structural overhaul. They proposed abandoning the singular nuclear option and replacing it with a graduated system of litigation limitation orders.
Graduated system.
This new architecture was heavily modeled on progressive legal reforms that had proven highly successful in the United Kingdom. Instead of one massive blunt force ban, the law would introduce 3 distinct tiers of orders.
So they could scale the response to the threat?
Exactly. This allowed the restriction on human rights to be carefully calibrated to the specific severity and pattern of the litigant's behavior.
Looking at this graduated system from the UK, it seems like the first step, the limited order is basically designed as a localized containment field for a single case.
It acts exactly like a localized containment field. The limited order is specifically tailored for the litigant who is obsessively making endless, frivolous procedural applications within the boundaries of one ongoing lawsuit.
Like the rubber ball strategy, just endlessly bouncing within one courtroom.
Right. Imagine someone who is trying to delay a trial indefinitely by constantly filing demand for irrelevant documents or repeatedly challenging the appointment of the judge.
How does the order stop them?
Under the reforms, a judge can issue a limited order which simply states, "You are prohibited from making any further interlocutory applications in this specific case without my express permission."
Crucially, it does not ban them from the court system.
Not at all. It merely forces them to stop stalling and proceed to the actual trial. And structurally, the most important reform was that any court or tribunal could issue this order, not just the Supreme Court.
That is a massive operational shift. It decentralizes the power.
Yes, it allows the local magistrate, who is actually watching the abuse happen in real time in their own courtroom, to instantly manage the situation without having to beg the Attorney General to intervene.
Okay, but what if the litigant's behavior has already mutated past a single case? What if they are utilizing the rolling thunder strategy?
That requires the second tier, the extended order.
The extended order.
This tier is specifically designed to combat the rolling thunder, or the rubber ball litigant who keeps coming back. If an individual is demonstrating a pattern of repeatedly suing the exact same victim, or widening the net to sue the lawyers, clerks, and witnesses involved in a previously resolved case, the court can issue an extended order.
And what does that do?
This order surgically removes their ability to bring any legal proceedings against a specific person, a specific organization, or regarding a specific exhausted issue without prior leave of the court.
So this is the shield for the furniture removalists.
Yes. It is a targeted shield. It guarantees the targeted victim the right to finality, legally protecting them from further harassment.
But it simultaneously preserves the litigant's fundamental human rights, doesn't it?
Exactly. Because the order is specific, if that vexatious litigant gets into a legitimate car accident 6 months later, they are still perfectly free to access the courts to sue the negligent driver.
Their general access to justice remains intact. They are simply amputated from their specific obsession.
And perhaps the most revolutionary aspect of the proposed legislation was that the victims themselves, anyone who could demonstrate a sufficient interest in the matter, were finally empowered to apply for this extended order directly.
So they didn't need the Attorney General anymore.
Subject to the court's permission? No. They no longer had to wait for the Attorney General to save them.
That fundamentally democratizes the protection. It empowers the victim to defend themselves. And then, I assume, if the litigant has completely lost all grounding, if they are the full scattergun, suing random banks, councils, and neighbors across every jurisdiction in the state, we finally reached the third tier.
Yes. The final tier is the general order. This represents the modern evolution of the old Section 21 declaration.
The nuclear option.
The nuclear option. It is the severe total ban on instituting any lawsuit in any court or tribunal without a judge's prior permission.
So it's still there for the worst of the worst.
Because this remains a drastic, systemic limitation on a fundamental civil liberty, the committee maintained that only the Supreme Court should possess the jurisdictional power to make a general order, and only the Attorney General or the Solicitor General should retain the authority to apply for it.
So what does this all mean for the future of the justice system? It means the law finally learned how to prioritize structural balance.
It really did.
By replacing a sledgehammer with a tiered, graduated system of orders, the law evolved to act with surgical precision.
It instantly empowers everyday working-class victims to seek their own protection.
It decentralizes power to allow lower courts to efficiently manage their own dockets. And it strictly preserves democratic human rights by ensuring that a citizen's freedom to access the courts is only restricted exactly as much as is absolutely mathematically necessary to halt the abuse.
It is a brilliant, highly practical evolution of legal philosophy. It firmly protects the democratic ideal of open courts, while pragmatically acknowledging that the justice system must have the architectural tools to protect itself.
And protect the public from individuals who have learned to use the complex machinery of the law as a sophisticated weapon of harassment.
Exactly.
Well, that brings us to the end of our deep dive today. We have traced the anatomy of a truly fascinating legal phenomenon.
A really complicated one, too.
Very. We started with the incredibly strict stratospheric legal definitions that separate the truly obsessive, vexatious litigant from the simply misunderstood, marginalized citizen fighting for their rights.
We explored the tragic, bizarre, and honestly incredibly mundane origin stories of people like Mr. A and Mrs. B.
People whose everyday disputes over unpermitted kerosene tin houses and marital furniture mutated into lifelong crusades that generated hundreds of baseless lawsuits and consumed their entire existence.
We unpacked the tense multidisciplinary debate between the medical and legal fields over whether to diagnose or simply sanction this behavior.
And how the concept of therapeutic jurisprudence offers a compassionate structural middle ground.
And finally, we analyze how the systemic failure of an outdated law led to a graduated system of litigation limitation orders, finally empowering everyday victims to shield themselves from financial and emotional ruin.
It serves as a profound case study on the intersection of human psychology and rigid legal structure.
Reminding us that a justice system is ultimately only as legitimate as its ability to protect innocent people from abuse, even when that abuse is perfectly formatted on legal stationery.
But I want to leave you with a final lingering thought to mull over as you go about your day. The extensive Law Reform Committee report we just unpacked was published in 2008.
Which feels like a lifetime ago in tech terms.
Right, that was an entirely different technological era. It was published before the massive global explosion of smartphones, before social media algorithms were designed to amplify grievance, and before digital legal documents could be filed instantly online.
Back in the 1920s, Mr. A had to manually type 120 proceedings on a typewriter, purchase physical stamps, and physically walk them into a brick-and-mortar courthouse.
Even in 2008, it required immense, tangible, physical effort and time to sustain the behavior of a vexatious litigant.
It was a full-time job.
But what happens to the architectural integrity of our justice system when the scattergun litigant discovers the power of artificial intelligence?
Oh, man. That is a scary thought.
Imagine a world, which we are rapidly approaching, where a disgruntled, hyper-paranoid individual no longer requires a typewriter, a stamp, or even legal training.
They can just prompt an AI.
Exactly. Imagine they can utilize an advanced AI language model to generate not 100, but 10,000 legally complex, flawless-looking, perfectly formatted lawsuits against their neighbors, local businesses, and politicians, all deployed simultaneously across multiple jurisdictions at the push of a single digital button.
It would completely break the system.
If our human-run courts, with all their clerks and judges, were already collapsing under the sheer paper avalanche of a few dozen litigants in 2008, how will the foundational concept of human justice survive the automated digital avalanche of vexatious litigation tomorrow?